All right. Hello, everyone. Welcome to our webinar, Estate Planning Basics, featuring Jon Murphy. Jon is an attorney that practices in the estates, trust, and probate group for the law firm Bailey Cavallari. He's represented clients in all aspects of estate planning, charitable giving, and estate/gift tax planning. I'm Eric Danielson. I'm the Communications and Client Services Administrator for AFP. We are recording this webinar, and we'll be recording future webinars as well. It should last around 20 to 30 minutes, and we will be holding a Q&A session afterwards. Excuse me. We will stop recording before the Q&A, and then this video will be posted on our website later, probably within the next couple of days. Now, in order to make sure this presentation runs smoothly, we have muted your mics and disabled your videos. So if you do have any questions during the presentation, feel free to type them in our chat. And if you see here, we have a little instructional for our chat. You basically just click the chat button, it pops up at the chat window, and then you can type any questions, comments, or suggestions you might have. And if you have any suggestions for future webinars as well, we also encourage you to post those in the chat as well. So with that, I will hand things off to Bob, Terry, and Jon.
Thanks, Eric. And on behalf of the rest of us at Alexander Financial Planning, we want to also thank you for spending some time with us. The purpose of these webinars is to educate, to explain a concept, or to possibly explore a topic that is of interest to you. We chose the topic of estate planning because it is a key component to creating and maintaining financial plans. There are a lot of misconceptions when it comes to estate planning, and there's a lot of terminology that is somewhat foreign to everybody. So we're hoping that some of the words we use, we can clarify, and we know that it just doesn't necessarily roll off of everybody's tongue. We decided to have a guest speaker for this topic, Jon Murphy. So thank you, Jon, for accepting our invitation. And our format's going to be a little bit different with this webinar. Bob and I are going to be asking some questions as we kind of go along. Jon has some slides prepared that we will be sharing. And then we're just trying to make it a little bit more free form, a little bit more communicative. So with that, Jon, my first big question is, what is estate planning?
Well, that's a good place to start. So estate planning is the process that you go through to make a plan to provide for what happens to your assets after you pass away. And there are a couple things about that that can be intimidating for people. Number one is just the phrase estate planning. Sometimes people think, oh, I don't have an estate. I just have a couple bank accounts and maybe a house, and that doesn't qualify as an estate. Well, I always tell people, don't let that term estate planning intimidate you, because you want to do planning for whatever it is you have. And then, of course, the other thing that's intimidating about the process is just the acknowledgement of mortality. But the other thing I tell people, and it's appropriate on a day like today that's rainy, you go outside when there's a threat of rain and you take your umbrella with you, and you're prepared whether it rains or it doesn't rain. And it's never too early to start thinking about estate planning and start thinking about your own mortality. It doesn't mean that mortality is imminent. It's just, it's kind of, in my mind, similar to a life insurance type analysis. You get life insurance to provide for your family in the event that you pass away, even when you're healthy and you anticipate living, many, many years. So, don't let the thought of mortality dissuade you from this type of planning, and we try and make it as pleasant and painless as possible.
Okay, so what are the documents? Because people get kind of tripped up on the different things, and obviously we labeled this simple wills and probate avoidance, but there's usually more than just the will. So if you could just kind of quickly talk about that, and then I know we're going to be talking about wills. Yeah,
so we'll talk about wills later in a little more detail, but I think most people have a concept of what a will is and what it does, but we'll get into that in a minute. But in addition to wills, I think most people really would benefit from having a couple of other documents as well. And Most of those are in the nature of power of attorney documents. So you can think of powers of attorney in two main categories, one being financial power of attorney. And that's a document that you sign to nominate somebody else to help you with financial matters, dealing with banks, dealing with the IRS, dealing with the state of Ohio, dealing with investment accounts. And that's a powerful document. So you obviously want to trust the person that you're naming in your financial power of attorney, but it can be really helpful if there's an unexpected illness or an unexpected period of incapacity due to illness or accident or even just being out of town, and something comes up and you need somebody to deal with a bank or a tax issue or something like that. The other big category for powers of attorney are healthcare powers of attorney. So a healthcare power of attorney allows you to nominate somebody else to make healthcare decisions on your behalf in the event you're not able to communicate those wishes on your own. So that's usually a family member or close friend. And on both these powers of attorney, financial and healthcare, I always encourage people to think about naming one primary agent, but then also naming an alternate one or two in case the first person that you name isn't available. Sometimes we sign these documents and years go by and the person you've named as your primary agent is no longer the ideal person or is no longer available. They've moved or they are sometimes not available. So it's good to name a couple of an alternate or two. And then the other document that often comes into play, maybe a topic for a future webinar, would be trusts. And trusts are commonly used in estate planning for various reasons, and we can touch on that a little bit later. But sometimes people think, well, if I have a trust, I don't need a will, and that's not the case. You want a will no matter what, but a trust is an instrument that you can use to handle some of these estate planning matters kind of in conjunction with a will. And if we have time, maybe towards the end, we can talk a little bit about when trusts are appropriate.
Okay, all right. So maybe we can go to the next slide, Eric, on wills, since they're kind of like the main document, driving document, I would say.
Yeah. So this slide goes over what the three primary purposes are for a will. And the first one, I think, is the one that people have in their popular imagination. What is a will? Well, a will is the document that you sign to indicate who gets your stuff, who takes possession of your assets after you pass away. And the fancy legal way of saying that is disposition of your probate estate. So the will, one important thing to understand is the will only governs assets that are subject to probate. And if you haven't had the opportunity, and I'm calling it an opportunity because I'm maybe that's an optimistic way to think of it, but if you haven't had the opportunity to serve as an executor for somebody, then you may not quite understand this distinction. But probate assets are assets that don't already have a joint owner or a beneficiary designated on the asset before somebody passes away. So taking, for example, an account that's titled jointly with right of survivorship. Husband and wife own a brokerage account that's titled joint with right of survivorship. Husband passes away, then that asset passes to the wife outside of probate. That's not a probate asset. Contrast that with an investment account that is solely titled in the husband's name. And let's in this example assume that this husband does not work with Terry and Bob, because if he worked with Terry and Bob, he would have a beneficiary designated. But in this example, he just has this investment account. It's in his name. It's not titled jointly. There's no beneficiary designated. So when he passes away, that asset is going to be subject to probate. Now, Terry and Bob are very good about having you update beneficiary designations on your various assets. And to the extent that you do that, those assets would not be subject to probate. So the probate estate governs those assets that kind of, in some respects, you can think of them as falling through the cracks. But a lot of times you have real estate that's just titled in an individual's name that will often go through probate. You have motor vehicles often go through probate. So it's those assets that are subject to probate that are governed by the will.
You know,
So
and
there's-
John, one other thing that we've done, and you may be aware of this, but for instance, when you do have a jointly named investment account, what we've done is we've further delineated the joint accounts as TOD accounts, transferable on death, because if something happens in a couple's in an accident where they both die, then it will allow the assets to bypass probate and go directly whom they've named.
Yeah, that's ideal. You want to have a probate avoided at the first death, but you also want to have a plan in place for what happens at the death of the survivor, or if there's a common accident. And those, of course, are very rare. But again, it's kind of like the life insurance analysis. We get life insurance to provide for our family in the event something happens, and you know, those instances are pretty rare, but we still like to plan for them.
John, can you touch on why do we want to avoid probate? What's the big deal with that?
Well, the short answer is it's easier for your loved ones if they avoid probate. They get the assets more quickly. There's not a separate process where they have to open a probate estate, have the executor appointed. And I'll just slide in number 2 on that list. The 3 primary purposes is to nominate an executor, and the executor is the person that handles probate. And probate, you know, going to your question, Bob, why to avoid probate? I will say this: in most instances, it's not as bad as people think. People have this idea like, oh, I got to avoid probate, and it's this quagmire, and it's a nightmare process. In most instances, it's really not too bad. The Franklin County Probate Court is pretty user-friendly. The Delaware County Probate Court is pretty user-friendly. But that being said, if you can avoid this process, it's easier, it's better, it's quicker, and it's less costly. When you are going through probate, there are probate filing fees, but more than that, there are fees that people like me get paid, because most people don't go through probate without the assistance of a lawyer. And so, you know, we do planning to help clients avoid probate, and by doing that, then hopefully they don't have to work with lawyers after their loved ones pass away. They can do some of this without having to open a probate estate. Now, sometimes probate can drag on and on and on when there's a dispute among beneficiaries. And again, that's another thing that's relatively rare, but we do see it, and it can make for pretty tense situations in the family. So, you know, the more that you can do to avoid probate, the better. And then just going down to that 3rd primary purpose of a will, this applies to parents of minor children. In your will, you nominate who you would want to serve as guardian for your minor children. And again, I suggest naming a primary person and then an alternate in the event that primary person can't serve. Those are kind of the 3 main things you're signing a will for. The other thing, you can specify specific assets, and maybe Eric, go to the next slide, because I think this may touch on the next slide, but these are some of the phrases that we talk about with respect to wills. You can include specific bequests or specific devises, and you know, clients don't necessarily need to know this terminology, but sometimes it comes up and you don't know what it means. A bequest is a cash gift under a will. So you know, if you say in your will, I hereby give each of my grandchildren the sum of $5,000 cash, that's a specific bequest. If you say, I give my grandson my pocket watch, that's a specific devise. So that's just a difference in terminology. Bequest is cash, and devise is a specific gift of a non-cash asset. And then the residuary clause, typically the way we draft our wills and most wills, they're kind of broken into separate categories. The first being like tangible personal property, which is household goods, items like, furniture, jewelry, artwork. The second category is generally real estate. And a lot of times real estate is going to avoid probate by virtue of being titled jointly with right of survivorship. But then we get to the residuary clause, which is everything else that hasn't been covered in those first two, tangible personal property and real estate. So that tends to be liquid assets, financial accounts that again are subject to probate. And sometimes you see that referred to as the residue or the residuary estate.
I love these estate terms.
Yes, it's a crash course in wills, trusts, and estates 101.
Yes.
Which is actually, some law school courses are more interesting than others, but of course, me as an estate planning lawyer, I thought it was pretty interesting.
Yeah.
Probably
Well, I do too, actually, but.
And this, speaking of law school, we can go to the next slide. Oh, well, this is a little joke slide I threw in that as an estate planning lawyer, you have to find senses of humor, and have to find humor. But I thought this was funny. I don't often have clients that are, the typical millionaire who's gleefully disinheriting people, but I still thought it was a little funny.
They can do that up to the last moment if they're not happy with somebody.
Yeah,
Right.
Yep.
They can.
Yep.
So this goes to that in the prior slide, we reference a couple terms. There's per stirpes distribution and per capita distribution. And this is a fun law school thing. If you think of law school estate planning classes as being potentially fun, but I'll walk you through the difference between per stirpes and per capita. So in this example, Tom, testator, and that's the legal term for somebody who makes a will. Tom, testator, makes a will, and he has 3 kids, Anne, Bill, and Carl. And in this scenario, let's say that Anne predeceases Tom. So a per stirpes distribution is what is kind of the default. I think it's what most people think of as being most fair, and it's sort of what we use most commonly. And so under a per stirpes distribution, the assets are divided into 3 separate shares. There's kind of the Anne share, the Bill share, and the Carl share. And even though Anne predeceases Tom in this example, Anne's kids split her 1/3 share. So they would each get 1/6. And then Bill gets 1/3 and Carl gets 1/3. Now, if instead of in the will, Tom said, well, I want my assets to go to my descendants per capita, then what that would mean is Anne has predeceased. Bill and Carl are living. And when you say per capita, you have to kind of use some additional language. You can't just say, I give it to my descendants per capita. You could say, I give it to my surviving children per capita. Mm-hmm. And that way you'd say, well, Anne doesn't get her share, but the kids of Anne get hers. And then Bill and Carl are both still living. So you have 4 who are going to take distribution under a per capita distribution, and they would each get 1/4. So Don would get 1/4, Eric would get 1/4, Bill would get 1/4, and Carl would get 1/4. And that's, per capita is just kind of by the head. Now, if you just said to all my descendants per capita, then you just count up the number of people that are living. And so in that scenario, Bill's living, and Bill's kids, Frank, Gary, and Helen, are all living. They all get an equal amount. That's pretty unusual. We usually stick with per capita because people think it's the most fair, and just kind of goes down by generation. And the idea is Bill's kids would eventually inherit from Bill, and Ann's kids take her share.
And this is a really important point, John, because we get into this a lot when we're dealing with the beneficiary listings on IRAs and 401ks and the like.
Yeah.
And if there isn't something there, all these institutions have a default in their language as to how this is actually going to take place if you haven't specified So many of them are per stirpes, I believe. And if you
Yeah.
want per capita, you really have to designate that on the form itself.
Yeah, yeah, that's important. And again, it goes back to the whole probate versus non-probate. A lot of people, they spend so much time thinking about what they're putting in their will, and they're fixated on that, and they may forget what they've done on their beneficiary designations, which really are going to kind of control some of those assets. So that's a good point.
Yeah.
I think we can move on. Yeah, Eric. Okay, so testamentary capacity, that's a fancy way of saying who is able to sign a will legally under Ohio law. So to sign a will, you have to be 18 or older. You have to be of sound mind and memory, and you can't be under restraint, which means you can't have undue influence at play. So if you are, somebody's coercing you to sign a will, that's the terminology we're referencing here, under restraint. You also have to sign a will. You have to have an awareness of what you're doing. You have to have an awareness that you're signing your will. You have to have a general understanding of the extent and nature of your property. Now, that doesn't mean you need to know account numbers memorized. You don't need to know, balances to the dollar. You just have to have a general understanding of what your assets are. And you have to know who the legal term in Ohio law is. I think the natural, I'm going to get it wrong, but it's like your natural bounty, meaning your family. And so this does come into play sometimes with some clients who are in stages of life where they have failing capacity to have a handle on this. And it's important to understand that this capacity can actually come and go. It's not necessarily a situation where, if you go one day to sign the will and you just find that the client doesn't have this capacity, you don't necessarily have to say, they can never sign a will. Sometimes you can go back the next day and they can hit these bullet points where they are able to have an awareness. It's, when a person starts to lose their mental capacity, if you've been through this, you may realize that, it's not a bright line where it's there 1 minute and it's gone the next. Yeah. But in that moment, they have to have this capacity. And so what I do when I meet with clients to sign wills is if there's any question whether they have this type of capacity, you want to have kind of maybe stretch the appointment out a little bit and have more conversations with them about, what's going on with you, what's going on with your family, maybe even touch on some current events to the extent that they're appropriate to talk about. Do they have an awareness of what's going on in the world? Do they have an awareness of what's going on with their family, their kids? And you can usually figure out pretty quickly. And thankfully, usually if I'm to the point where I've prepared documents and I'm meeting with the client, usually they have capacity. There are occasions where it's a gray area, and the family members who are, kind of helping them and working with them can kind of, get them in position where they're, sometimes they're better in the morning. And so we work with them to have an appointment in the morning, and you just have to kind of be aware of what goes into this. But this can be an issue, this capacity.
So John, just in the sense of, you've been kind of focusing on the older end, how early on should people have a will? I mean, should they be 18? What dictates when a will really should be put in place?
Well, the short answer is it depends on what their assets are. But if you have an 18-year-old that has assets in their name that are somewhat significant, then they might consider signing a will. But you think about, well, what would happen? What would the default be? And the default under Ohio will is if somebody passes away, then their assets would pass to their spouse if they have a spouse. If they have a spouse and children, then it passes to the spouse if the spouse is the other parent of all the children. Okay. Now, if they have children from a different marriage or a different relationship, then it can be a little bit tricky. And the Ohio default law, has these formulas where the spouse gets a portion and the kids get a portion. So the short answer is, if they have kids, number one, you definitely want to have them signing a will. If they're married, you probably want to have them signing a will, or if they have assets, any significant assets, you probably want them to start thinking about signing a will. But, I don't have many 18-year-olds coming in to sign wills. I'll tell you that.
Well, the one thing we do with clients who have kids that are turning 18 is it's like, happy birthday, but you need to get power of attorneys in place for
Yes.
health and financial
Yes,
on them. And
that's-
that seems to be one that most people aren't clued in on. I know it's
Right.
not the will, but it's,
Yeah. And I think that's important, especially as they're going away to college.
Yep.
The financial power of attorney and healthcare power of attorney, particularly if mom and dad are being generous enough to pay for the schooling. Sometimes it's really helpful to name mom or dad or both on a financial power of attorney so they can deal directly with the school, because a lot of schools, the loan paperwork and the bills are sent to the student, but it's really mom and dad that are paying. And that's not to say I think it's good to have the kids involved, and that's a life lesson, and you want them to be aware of how much school's costing and what goes into it. But at the same time, it can be really convenient if mom and dad are named on that power of attorney.
Okay. Eric, next slide. I don't remember what it is. Oh, probate.
Okay, so probate avoidance, we've already kind of touched on this, but you want to avoid probate to the extent you can, and various ways to do that. Setting up trusts, that's a way to avoid probate, and you can transfer assets to a living trust in your lifetime, and you can name a living trust as your beneficiary on account. So you can say, at my death, I want everything to go to my trust. And I'll circle back to trust here in a minute, but pay on death accounts or what you can do at the bank. You can go into the bank and you can say, I want to add my kids as the pay on death beneficiaries for my bank account. Transfer on death, it's kind of an exchangeable term with pay on death. Transfer on death is the same concept. You're adding beneficiaries to take your asset at your death. Joint and survivorship ownership is a little bit different, because that's a change. If you have an account in your name and you change it to joint and survivorship, that's a current change. So you're making whoever you're naming as the joint and survivor owner, they become a current owner, and upon your death, they would become the sole owner. And the other thing you can do, we're going to get another little legal term here. You can make an inter vivos or inter vivos gift, and that's just a gift during your lifetime. If you give something away during your lifetime, it's not going to be subject to probate. And one thing that comes into play sometimes is people have reference in their will to something that they have given away. So, I can make a will today and I can say, I give my car to my spouse, but if after signing the will, I end up giving the will during my lifetime to my son, then the car is no longer part of the probate estate, and it doesn't matter what the will says.
Okay. All right. On to the next, I think. Here we go.
Okay, and this is the best probate avoidance technique of all, and that's just to spend it all in your lifetime. His will reads as follows: being of sound and mind disposition, I blew it all. So, you can blow it all on a trip to Mexico or Hawaii, or you can,
Anywhere.
Yeah, you can.
Yeah, today with inflation, you might be blowing it all.
Right.
Yeah. So that's probate avoidance. I don't know that that's the best way to treat your survivors, but that's one way to avoid probate. But just circling back to the trust, because I think that's something that a lot of people come into with questions about a trust, is when is a trust appropriate? So it can be kind of in a sense, the term will substitute is sometimes used, but you still want to have a will when you name a trust as your kind of the primary vehicle for your estate, in your will, you can actually say, all my assets that are subject to probate should go to my trust. And then in your trust, you can control the ultimate disposition, but it can become really helpful when you have minor children, for example, because you can specify in the trust the age at which you think the children are old enough to take those assets outside of the trust. And in the meantime, you get to name who the trustee is to handle those assets for the benefit of your kids. The default rule for minors is they get assets at age 21. In a trust, you can say, well, I think I'm comfortable with them getting a third of their assets at 21, and then they can get half of what's left at 25, and they can get the rest at age 30.
Mm-hmm.
You know, a trust is very flexible. A trust can also be helpful as just kind of a place where you can consolidate all the assets outside of probate. You just name the trust as the beneficiary on your various assets, and they all go into one spot, and then they can be divvied out among your beneficiaries. And then trust can also be helpful in planning if you are one of the few clients in today's estate tax world where you have estate tax concerns. Right now, the estate tax affects very few people. The current exemption is 12 million. So that may be cut in half here in a few years, but unless you have amounts above that, you're probably not worried about the estate tax. But if you do, we have all sorts of planning techniques to help you manage the estate tax, and a lot of those involve trusts.
Yeah, and Ohio got rid of their estate tax a few years ago. The other thing we run into, John, is when people do name trusts as a part of their beneficiary of their retirement accounts, and then understanding, and we do have to have a program on just trusts, what a see-through trust is and the importance of that. So that's a whole nother can of worms, but it is critical, or you can create some real problems.
Yeah, so that's very important, is when you're naming a trust as a beneficiary for qualified retirement assets, IRAs, 401ks, you need to make sure it has that see-through language, so that, and what we mean by that is under the IRS Treasury regulations, they want to be able to see through the trust to see who the beneficiary is, so that that beneficiary is treated as essentially an owner of an inherited IRA, to get the benefit of tax deferral the way that an individual would. And the other thing that's important now too, because of a recent change in the law, is you want to see language that allows accumulation in the trust, rather than what kind of was the default before this change in the law, the Secure Act, which passed a few years ago. A lot of people were trying to include language that sort of forced the trustee to pull the assets out and get it to the beneficiary. Well, now you have 10 years to take that retirement account out instead of the lifetime. And some of this is still kind of a gray area. They're still working on some of the regulations, but generally you want the trustee to have the flexibility to either allow those retirement assets, when you're pulling them out of the retirement plan and into the trust. You can think of kind of two levels. There's the retirement plan, there's the trust, and then there's the beneficiary. When they get pulled out of the retirement plan, you sort of want the trustee to have the ability to accumulate those assets in the trust and distribute them out to the beneficiary as the trust provides, rather than forcing them out because of the way that the law change. That can cause some unintended tax consequences if big amounts are coming out in 1 year and then you're having to distribute them to the beneficiary. It just may not be what you want. So I like to include that in accumulation language.
Yeah, that part has gotten a lot trickier with the Secure Act.
Yes, for sure. And we're maybe getting a little into the weeds there, but that's important to think about.
Okay. Well, I think the next slide is the question slide. And we can probably open it up here for anyone that is on the call that would have a question. But so just before we do that, John, thank you for doing this. It's been great. And why do people need an estate attorney? Why would they need to? I know they can do documents online, they say. So why would you need to have an estate attorney?
Well, I think the value of an estate attorney is walking you through the process and helping you understand the implications of some of the different terminology, the differences between probate assets, non-probate assets, when a trust might be, appropriate. And I think the risk you run when you're doing this online is just not fully understanding some of these distinctions. And frankly, we see these types of situations come in. A family will say, well, my mom passed away. She did a will on LegalZoom and here it is. And we see the will and it's like, well, there are certain things that just get missed. You may not understand the nuances of, well, you want to appoint an executor who's in state rather than out of state because there can be additional fees there, probate fees, probate bond fees. You want to make sure the will dispenses with bond. Sometimes we see when people have prepared their own will, they don't dispense with the bond requirement, so that's an additional fee. And so sometimes people think they're saving a little bit of money by doing their own documents or doing LegalZoom or what have you, and they end up saving money on the front end, but it ends up maybe costing more on the back end. So I just tell people to be cautious there. And the other thing to be cautious about is sometimes some practitioners, I think, use a little bit of scare tactics with respect to Medicaid. You may get flyers in the mail from lawyers who are, they're licensed to practice law in the state of Ohio, and sometimes they do a great job. But I just get nervous. I mean, I get these mailers too, and they're inviting you to a chicken dinner to come hear about estate planning, and they tend to sometimes use a one-size-fits-all approach. And a lot of times it's really predicated on fear. The government's going to come take your assets and you're going to have to go to a nursing home, and here's how we avoid that. And
yeah, we've been through a few of those situations too, along with veterans benefits and qualifying for those, and them saying that we can get you approved for this. And it's there are a lot of shenanigans out there, and you got to be careful with that.
You need to be careful. And sometimes that is the type of planning that people are legitimately looking to do. And I don't do that type of Medicaid planning myself, but I have great referrals for people who do. But I would just be cautious about making decisions about transferring your assets during your lifetime to avoid a problem that you may not fully understand.
Or you may not have that problem.
You may not have that problem. Yeah, that's exactly right.
Yeah.
And we had a question come in about the average cost of a simple will and powers of attorney. So what is when an average, John, if you can?
Well, it definitely depends on whether it's a simple will versus trust. So, and I'll tell you this, I can only tell you how much things typically cost for me. I'm confident you'll find lawyers who charge more, and I'm confident you'll find lawyers who charge less. But for me, if you're looking at a simple will, usually there's the simple will, but there's also the power of attorney documents.
Right.
But if you're just looking at a simple will and the basic power of attorney documents, maybe for just one single individual, that might be around $1,000, give or take. If it's for a married couple, that might bump it up into the 1,500 range. And don't hold me to these. These are just kind of averages and estimates. But when you get into the trust planning, that, we're always doing that for a good reason. I'm not recommending trusts just by default. If people can get away with not having trust, then we do a simple estate plan, and that can be appropriate in a lot of cases. But if trusts are involved, that can increase the fees, pretty significantly. So an estate plan for, let's say, a married couple with wills and financial powers of attorney, healthcare powers of attorney, and a trust in play, that can be in the $2,500 to $3,000 range. But as part of that, we make sure you know what to do with all your beneficiary designations. We address what you want to do with your house to make sure it avoids probate. So it's kind of, we're trying to do the whole picture there. But that's sort of where things typically tend to wind up.
And John, one other question, how frequently should people review their estate documents?
Well, it's a good idea to review it every few years, particularly if there are significant life changes. You know, if you move out of state, or even if you just move, you want to make sure you're handling your new house the way you want to, and that's a good time to just review the whole estate plan. If you have kids, absolutely, you want to review your estate plan. If your kids graduate college, you want to review your estate plan. Plans tend to get more sort of complex as people have kids and they're minors, and then they can sometimes get simpler as those minors become adults who are fully functioning humans who, you know, you're comfortable with just inheriting assets. So sometimes we have a trust in place, and we can do away with the trust as kids get older. But what I typically do when I work with clients is I will docket a follow-up. I'll have my assistant docket a follow-up in 4 years. And we'll just by default send a letter saying, hey, it's been 4 years since you signed your wills and your trust. You know, maybe think about reviewing those and let us know if you want to update them. If we don't hear from them that go round, we'll docket a follow-up in another 4 years. So a lot of times people get those reminders and I hear from them and they have changes they want to make.
Yeah.
So,
okay. Yeah, we typically will tell people 3 to 5 years. So that's kind of falling into that place. And it is more those triggering events that definitely could cause people to say, we need to get this done. One other thing would be the digital estate rules. And that could trigger people because they may not have that in their estate documents right now.
yes, that's something that has evolved pretty quickly, as people can appreciate. So wills that were done 10 years ago probably don't have the digital asset language that most people need now. Sometimes you talk to clients and they say, oh, well, I don't really have that much in the way of digital. And then you start talking to them. It's like, well, you probably have more than you realize. Right. You have passwords, you have social media, Facebook. So that's a whole nother, we could do a webinar on that topic.
All right, we got 2 set up for the future. That's awesome.
Yeah. But that's, you want to look into, look at your will, make sure it has that digital asset language. Look at your financial power of attorney as well. Make sure it has that digital asset language. Your trust, if you have one, should have that, because you want your trustee, you want your executor, you want your power of attorney to be able to access those assets and do what they need to with them.
Okay, well, great. Well, thank you, John. I don't know, do we have any questions, Eric, out there? I know we asked.
There was the one that came through that Bob mentioned, but other than that, we haven't gotten any yet. But there's our disclaimer.
I should throw in my disclaimer. I'm a lawyer, so I need to say I did not give anybody legal advice.
Good advice.
This was just like a general discussion.
Informational only.
I have not established any client attorney relationships as a, maybe I will down the road as a result.
Maybe, right.
But feel free to give people my, my name and contact info, and I'm happy to answer questions.
Well, and John, you are listed on our website under our
Centers of Influence.
Okay.
Under attorney. So your contact information is there. And I'm glad you mentioned that, because that prompted me to remember to say that.
Well, I appreciate that. You guys are so good at referring folks to me, and I do appreciate that very much.
You do really good work, John.
Well, thank you.
Mm-hmm.